Please give me the.
Item number 1.
Why you have kept this missing? No, yeah, this matter will take it up on 10th itself. There was some confusion whether this bench will sit on 10th. That's why we kept it. It will be on 10th itself.
On 10th.
As fixed.
10th? 10th, next month. My daughter.
It was fixed on 10th. So there was there was a possibility that this bench will not be sitting. That's why we kept this matter as we mentioned. But this bench will sit on 10th, so we'll take it up on 10th.
Can it be on?
And you file it your written notes of argument in the meantime.
May make a small prayer, my lord. Other than 10th, any day, my lord. Other than 10th.
No, but are you ready to argue today?
My lord?
Are you ready to argue today?
My lord, it is. I have brought up the judgment. I have already preached.
No, are you ready to argue today?
Yes, my lord.
Then we hear you. Are you ready also?
Yes.
Then let us hear the matter. Huh? It's better hear the matter.
Only because my 10th, my lord, I have got one matter.
No, doesn't matter. You just, if you are ready, we'll recall that order and hear the matter today. So no problem. You can just tell us first matter.
This writ appeal is referred against the judgment of the learned single judge passed in WPC number 196 of 2023, dated 17/2/2025. What happened, my lord?
Give us the other papers. Give us the other papers. Where is the interim judgment? Give that file. Give that file. No papers, sir, but it's referred to you. Yes.
My lord, what happened, my lord? The appellant before your lordship is denied benefit of third MSCP, given admissible to him, as well as promotion to the cadre of my lord Subedar clerk, on the ground of that he is found ineligible because of below benchmark, uncommunicated below benchmark getting,
Yes.
and it was never communicated. Being aggrieved, he has approved the learned single judge, and the learned single judge remanded back the matter with a direction to the respondent Sasam Raifel to communicate all the downgrading adverse SCR, and thereafter the appellant should make a representation before the authorities, and they will consider the representation.
So how you are aggrieved by this order?
Because, my lord, now all the judgments says it should be ignored. Right from Prabhu Khandawal.
No, if they don't ignore it, see, it's a writ of mandamus, correct? So the basic principle is this, that what the statutory authorities ought to have done, they have not done so, then they are required to decide the matter. Only in exceptional circumstances, the mandamus is directed by a writ of mandamus. What they have done, what they are supposed to do, the court have also directed the same thing. But ordinarily in a writ of mandamus, if they are supposed to discharge their function, if they have not discharged their function, so first direction will be upon them to decide what they should do. If they do something ignoring it, suppose they ignore a judgment of the Supreme Court, you will always have a right to challenge it.
Now,
so this order is a mandamus was directed to them, and there is a time frame also. So how you are agreed by this?
Because your lordship, it is 2016.
That's
17.
why 1 month time was given to them.
Not that, because at that point of time, the downgrading SCR is there, my lord. Now in 2025, and all the judgments.
Now let us see what they decide. If they ignore all those judgments and pass anything against you, you have a right of remedy.
My humble submission, your lordship. My humble submission.
Yes.
I will read out all the judgments. That
We
question
are not,
of
at this stage, you are not required to go into that question. At this stage, you are not required to go into this question. We said that you made a representation, you refer to those decisions. If they ignore it, and still then they pass an order, then you have a right to challenge.
My lord, may I draw your lordship? Only I'll read out those operative part of the judgment, my lord. In all the cases, all the cases says
No, we
that it
record
should be
that
ignored.
you record that these are the judgments you relied upon to show that they cannot take this into consideration. While deciding on representation, they will take into consideration this point and decide.
Lordship may then pass an order, my lord, that the judgment should be, I will refer the judgment.
If you are in your representation, if you are referring to those judgments, then they are bound to follow consider this. How they can ignore it? If they ignore it, there's a
If some observation is there, my lord, if some observation is there, judgments are on record, my lord. All the judgments are on record, right from Prabhu Dayal and the latest judgment of the register Manipur High Court versus
No, but you cannot rely upon the adverse entries without communicating to them. That's a settled law.
there is a certain.
My lord, the reference is made to, if Lordship kindly turns to page 217, my lord. This is Abhijit Ghosh, the judgment.
No, 217.
217, my lord.
Yes.
This is the three-judge bench.
Yes.
Abhijit Ghosh, my lord. If I may take your Lordship to the next page, my lord, para 8.
217.
Yes, my lord. My lord,
What is the name? Yes, it's very well. Yes.
yes, my lord, 217, my lord. This is the judgment, my lord, 2009, volume 16. Para 8, your Lordship kindly sees, my lord. Other than the armed forces, my lord.
No, this has carved out except he's in armed force.
He's an he's Assam Rifles, my lord.
It's a central paramilitary force, my lord, not armed force. Central paramilitary force. Not armed force, my lord. KK Dination case, it was dealt.
No, but now because of this decision,
My lord.
are you not supposed to communicate him the adverse entries?
No, my lord, we are communicating, my lord.
You have
My lord,
communicated.
what our rules say, my lord, if the entries are not adverse, then only adverse entries will be communicated, my lord. That's what our rule says, my lord.
No, but then you say there is no adverse entry against him.
Now, adverse has a different consequences, my lord.
That's what I'm saying.
My lord.
So what is adverse to you may not be adverse to the other.
My lord. But that
But
is
if it affects his promotional avenue by reason of those entries,
my lord.
suppose you put someone good or say satisfactory,
My lord.
and he has a right to demonstrate that it's not satisfactory according to your guidelines or extent rules, he's supposed to be considered as good or very good.
Exactly that
Because
is
because that is a kind of denial of promotion.
my lord.
And denial of promotion is in fact, if you are not considered his promotion gives him some kind of right. When I joined the service, right to promotion is there. You cannot listen. Supreme Court says it's akin to a fundamental right to promotion.
My lord.
So that you have to consider.
But my lord, the argument that if it is adverse and is not communicated, my lord, that has to be ignored and he has to be granted promotion positively, my lord. That in my
Now that you consider on the you communicate the adverse entries if you have communicated.
my lord, because they immediately came to the division bench. My lord.
You have not communicated as yet.
have not-
Very well. Take down.
Even in their own rule, record of instruction that was noted in a separate, a different case.
Please, just listen to the order. Although this matter was
All right.
Yes.
All right.
Thank you. This also we can take it up on 10th.
Well,
Uh, this eight, nine, the conference is there.
May I please lodge?
It's a criminal appeal.
It's a writ appeal lodged from the single bench. So I filed an application for donation of delay. There's been a
Who is
delay.
there? You are there?
Yes, Lordship.
Condone.
I have no.
Condone. 84 days. Register the appeal.
उसकी application no.
You have not filed any stay petition.
No, Your Lordship.
Very good.
Number 4.
Yes, respondents are represented.
May it please, Your Lordship. Lordship, I've just been engaged for the respondent number 4.
Oh, very
I'm
well.
waiting for some time to file my power.
Now, which for the appellant?
I'm for the appellant.
Now, you are for the respondent number 4.
Yes, Your Lordship. I've just been engaged.
You have filed any stay petition?
Lordship, stay has been granted, Lordship. In the
Stay has been
motions.
granted.
It's a stay operating. Order dated 30th May 2000.
Oh, you directed fresh election.
Lordship.
So that has been stayed.
Lordship.
I think better we place this matter before this bench. This matter should be heard by the bench which has granted the stay. It's better.
Lordship.
Because they have applied their lordship's mind.
Lordship.
Stay down. Yeah, applied your mind. So it's
My lords, as per the directions of my lords, we have served the copy. There's a delay of 30 days, my lord.
you are representing.
Well, as I am here for 1 and 2, my lords, there's a Public Service Commission. We are not objecting to the delay.
Three,
My lord, I'm appearing for 4, my lord.
three,
My lord, I'm appearing for number 3.
three.
Lordship.
Achha, 5 has filed any affidavit before the trial court, before the learned single judge.
The
It
five,
appears
my
that
lord.
1 and 2 has filed,
My lords,
and 3 has filed, and 4 has filed.
my lords.
But what about 5?
Lordship, I have filed. I filed it before the lunch.
You have filed an affidavit, but that is not included in the stay petition.
My lord,
171, my lords, if I'm not mistaken.
171.
Just a second, I'll just clarify.
171. Yes.
It's by R4, my lords.
No,
I'm
this is
sorry.
by 4. I'm saying 5.
My lord, at
Five, my lord,
page number 222, my lord.
222.
222. Sorry, then I might have missed it. 222.
Yes, 222, my lords. Annexure 6.
Very well, very well. Should we hear out the appeal today?
my lord, may I pray for another 2 days, my lord? Just recovering from.
Oh, I see, I see. Did I condone the delay?
My lords.
Yes.
Item number 6, my lords, I am instructed of preparing for the appellant, my lords. The appellant does not want to pursue this matter any further. They seek to withdraw this matter, my lords.
The appellant is not willing to proceed with the matter.
My lords.
Very well. But where is the letter of instruction?
Well, it's if your lordships so
Yes, it's
permit
better
us,
because
we'll
don't take
bring
it upon
on record,
yourself.
my lords. We'll bring
Don't take it upon yourself.
My lords.
From my experience, I'm saying this.
My lords, I bow down, my lords. I'm grateful.
The land council from the over.
Item number 1.
Oh, yes. Yes. Who is for the, you are for the?
I'm for the writ petitioner, my lord.
Yes, yes.
My lord, as per the last order, my lord, the notes, my lord, my apology, my lord, I couldn't prepare the notes, my lord. I need some more time, my lord.
Lordship, similarly, my lord, we are praying for some more time to prepare the notes, Lordship.
You?
We are here for the
Yes,
state,
yes,
Lordship.
yes. So your argument, this
Yes,
is,
my lord.
this we have, according to them, they want to judgment that was passed by this.
Passed by this honorable court, my lord.
You start, we shall sit with and then you file your notes. Let us-
Yes, my lord, we can argue, my
Start
lord.
the hearing.
My lord, yes, my lord.
What was the judgment? Please show us first.
Yes, my lord.
And please tell us in brief what was the matter.
My lord, yes, my lord. The writ petitioner herein, my lord, are the district council lower primary teachers, my lord. They were appointed
Yes.
prior to the taking over of the act, my lord. The school, LP schools were governed and run by the district councils, my lord, in the state of Meghalaya. Then, my lord, on the failure on the part of the district council, the state government come out with an enactment, take over the schools, my lord, LP schools, my lord, LP and primary and basic schools, my lord. The act, my lord,
This is 1993.
yes, my lord, 1990. Meghalaya taking over of district council school, my lord, 1993 act, my lord.
Yes.
Connection. Then, my lord, under the act, my lord, kindly annexure 3, my lord. My lord, the parent act, my lord. Page 33 in my writ petition, my lord.
Page 33.
Page 33 of my petition, my lord. Under this act, my lord, section 2 is the definition clause, my lord. Section 2 is important, my lord. Section 2, clause E, my lord.
33 section.
Section 2, clause E, page 33 itself, my lord. May I read, my lord?
Yes.
The DCLP schools means any primary school, including a junior basic school managed by the district council. That is the definition in the parent act, my lord. The first act, 1993 act, my lord. After this, my lord, come out with the, after the passing of this act, my lord, there is certain benefits which is occur due to this act, my lord. The primary school teachers are availing some benefits, my lord. Thereafter, a set of teachers approached the Honorable High Court in Guwahati bench, my lord. Then direction were issued, benefits were released, my lord, to the primary school teachers. Thereafter, my lord, the petitioner herein is the pre-primary, my lord. There's a two sect of teachers, my lord. One is LP teacher, lower primary, and another is pre-primary, my lord. We are the pre-primary, my lord. Then LP teachers approach this honorable court, the High Court of Meghalaya, my lord. Then, my lord, kindly have page 38, my lord,
Yes.
of my petition, my lord. That's the first order, my lord. Writ petition number 208 of 2025. The
Yes.
pre-primary teachers approach this honorable court, and after the hearing of the matter, the learned single judge has passed the judgment, my lord, on 17/5/2017, my lord, whereby the judgment, my lord, kindly the important paragraph, my lord, the relevant portion at page 41, my lord, paragraph 6, my lord. May I read, my lord? After careful analyzing the word used under section 3, clause 1 of the Meghalaya taking over of the District Council Lower Primary School Act 1993, it is clearly understood that the act is silent to make any kind of restriction between the pre-primary teachers and primary teachers, as the word used in the said section DCLP schools means the District Council lower primary schools, since the Act is silent to define anything separately about the pre-primary schools. In my opinion, pre-primary schools also falls within the ambit of DCLP schools, since there is no different segment between the pre-primary schools and primary schools. I am of the considered view that the benefit which the pre-primary school teachers are enjoying as on today, some benefit should be given to the pre-primary school teachers. On the other hand, also, I do not find any reason that in the same schools, some teachers will be termed as pre-primary teachers and primary teachers and having certain benefits, while some will not get the benefit. This also amounts to violation of Article 14 of the Constitution of India. Therefore, the respondent's authority is directed to give the same benefit to the pre-primary school teachers as well as to the primary school teachers. There is this judgment, my lord. After this, my lord, the state respondent challenged this, the judgment of the learned single judge, my lord. Then, my lord, the learned division bench of this honorable court has
No, we understand.
Yes, my lord. The same judgment was upheld by the division bench of this honorable court, my lord. Thereafter, my lord, another set of teachers who were left behind again approached this honorable court. During the pendency of the writ petition,
No, you are challenging page 57. You are challenging this amendment.
We are challenging the 2 Amendment Act, my lord, whereby section
What is
2.
2018?
Yes, my lord.
2018.
2018, my lord. There's a 2 amendment.
2018, this amendment was there.
2018, there's a 2
DCLP
amendment.
school means in a primary school, including junior basic school, managed by the district council, but excluding the pre-primary.
Pre-primary, my lord. That is our
This you
only.
are challenging.
That is we challenge, my lord.
On what basis?
My lord, the first argument is, my lord, number one, by this Amendment Act, the state government has overruled the judicial pronouncement, my lord. Second is, by this Amendment Act, the state government has created a separate class, my lord, among the class, my lord. The third is, my lord, the basic structure doctrine, my lord, the separation of power. They violate the separation of power, my lord. The 3 argument, my lord.
See, subject to hearing other side.
Yes, my lord.
The judgment of Justice Sen,
Yes, my lord.
upheld by the division bench, was on the ground
Yes, my lord.
that there is no classification made between these two classes.
Yes, my lord.
In absence of a classification, and is vague.
Yes, my lord.
So on that reading, the pre-primary section teachers will also be benefited because the definition is rather vague, as it does not make any distinction within 2 classes.
Okay, my lord. Yes, my lord.
Now the second amendment of 2018 now make a classification.
Yes, my lord.
It's not a question of nullifying the judgment. It's a question of now creating a class between the two.
Yes, my lord.
Because admittedly, who are in the lower primary and who is in the pre-primary, there are 2 different teachers, set of teachers.
Well,
Just a
teaching in
minute,
the
there are
same.
two different set of teachers.
Yes, my lord.
In the definition, the contention of the state appears to be that this only covers maybe the junior basic school, junior basic school, but exclude the pre-primary section.
Pre-primary section.
This was not accepted by Justice Sen and also the division bench on the ground that the section does not make any distinction.
Distinction. Yes, my lord.
So if the basis of the judgment, whatever may have been the defect in the legislation, because it says that it was a vague.
Wait. Yes, my lord.
All of them, the single bench and the division bench both said
Yes, my lord.
that is vague. Now it has been clarified.
Yes, my lord.
Now, unless it is not subject to what you say, it's not a kind of nullifying the judgment,
Yes, my lord.
but creating a classification.
Classification. Yes, my lord.
Now, what possibly you could argue is that this classification is bad, maybe
Yes,
violation of Article 14.
Yes, my lord.
That is not the same thing as it is overruling the judgment, isn't it?
Yes.
the basis of the judgment,
Yes, my lord.
it's not that it hits at the judgment. The legislature failed to clarify this.
Yes, my lord.
So because both the courts, the single judge and the division bench said
Yes.
that since they have not made any classification, this benefit should go to them.
Yes, my lord.
Now the classification is made.
Yes.
So you have to satisfy us that this classification is wrong.
Yes, my lord.
Now normally the power rests with the legislature
Yes, my lord.
to make a classification.
Yes,
but there has to be a rational basis.
Rational basis, yes, my lord. The two tests has to be fulfilled, my lord.
If they are discharging the same kind of duties,
Yes,
same performance, same kind of recruitment, same syllabus they are teaching, then possibly what you say, this classification may be violative of Article 14 of the Constitution of India.
Yes, my lord.
Otherwise, if they are completely for different purposes and there is an intelligible differential,
Yes, my lord.
then of course that is a judgment in S.R. Tendulkar's judgment.
Yes, my lord.
So in that case, this is an intelligible differential. If it's there, then this is perfectly all right.
Yes, my lord. That is one of the argument also, my lord. By this amendment, the state legislature has created a separate class.
That's a different issue. That's a different issue.
Yes,
So
my lord.
you are challenging it on two issues.
Yes, my
One is it is try to nullify the judgment.
Yes, my lord.
The second thing in the alternative, your argument is
The
that
violation
there
of-
is no intelligible differential.
Yes, my lord.
So violation of Article 14.
Yes, Article 14, my lord, discrimination. And my lord, the similar issue, my lord, the same argument which my lord has forwarded, my lord.
No, I have not provided an argument.
my lord-
I have just given my view.
My lord,
I have not
division
argued
bench,
for or
in
against.
the order of the division bench, my lord. The learned division bench, after hearing the matter, my lord, at length regarding the, my lord, aim and object of the Parent Act, and the definition clause, since the definition clause is silent, and since they are teaching in the same school, the pre-primary and the primary in the same schools, same syllabus and same subjects, my lord. So therefore, they have upheld the order of the learned single bench.
You have filed your affidavit, madam.
They have filed, my lord.
Lordship, we filed, my lord, and we've also filed a compilation, my lord. Lordship.
You have filed already.
No, Lordship. We've
Please file a
prepared, my lord.
compilation.
We're filing, my lord.
Give a copy to your friend.
Lordship.
These are the compilations of.
Compilation of the journey of the cases from 2015 before learned single judge, my lord, up to the decisions as to why the 2018 notifications have come into effect, my lord.
You have given certain judgments.
Lordship. We have given many judgments, my lord.
But for what proposition?
That as to why the notifications, the amendments were made and why they can have retrospective effect, lordship.
You have filed. It was filed. No, but you have disclosed the affidavit opposition of 2019.
Lordship, we have, my lord.
No. We want to know, have you filed any opposition to this?
Yes, my lord. They have filed, my lord.
They have filed.
We have filed, lordship.
And you have filed your reply.
No, my lord, I have not filed a reply, my lord.
You want to file a reply?
My lord, my lord, actually in the affidavit of opposition, my lord, just simply, my lord.
We filed one affidavit in opposition,
Yes,
my
ma'am.
lord, and we filed an additional affidavit, lordship.
Also additional affidavit.
Additional affidavit also
What is
filed,
the
lordship.
additional affidavit?
We filed it on the 5th of May, 2025, lordship.
Very well. Now you want to file an affidavit to this?
But I'll reply to that, my lord. Then in that case, my lord.
My lord, my friend had submitted on the last occasion that they will not be filing any
My
reply,
lord,
lordship.
My lord,
Gotcha. They have
They
said.
had already
I have
submitted, my lord,
but,
that they will not
since-
file any
But still,
reply.
if they want to file,
Yes, my lord.
They-
I'll reply to that, my lord.
yes, that was recorded. You are absolutely
Lordship.
correct.
Yes, my lord.
So you don't want to file?
But I'll reply, my lord. My lord, kindly.
well. Preliminary submission on behalf of the Send this file. Yes or no? Yes, what is this matter, please? Yes, which for the petitioner.
But, this is against the order passed by CAT, my lord. Central Administrator.
Yes. Yes.
But the issue primarily revolves around grant of SCP and MSCP, my lord. I prepared a brief list of dates, my lord, that will for assistance for lots of attendance.
Sorry?
I prepared a list of dates, my lord, for lots of assistance.
He's already there. It's already there. His lordship may not have this. Yes, sir. In the same. Yes.
So, my lord, if I may take your lordship to the list of dates, my lord, he was appointed on 12/11/1984 as Hindi instructor, my lord. 26/5/98, a higher post of Hindi officer was created in the academy, my lord. And simultaneously, the post he was holding was abolished. In 98, he was promoted, my lord, to that particular post. Now, there is some ambiguity, my lord, whether that was a promotion or it was a fresh appointment of the respondent, my lord. That is where the entire issue revolved, my lord. He was appointed to that newly created post, my lord.
No, appointment is done once. Others are only promotion.
But here,
appointment is other things are only promotion.
well, I follow, my lord, but this is a slightly peculiar, my lord. Yeah.
You can have only appointment once.
But if you lordships take up the writ petition, my lord, at page 17, my lord.
But you have proceeded on the basis that he was promoted. Your case is not, because once you extend him the first SCP, that is from 84, not from 98. Otherwise, he would not be eligible for the SCP in 19, according to a list of dates, in 1999. It was only you counted 12 years service from 84.
But because he was promoted, he was not. My lord, there is ambiguity. I admit that, my lord. There is ambiguity on the part of the
The
department.
financial, he's being represented by the legal heirs.
But that's true.
I think so. Legal heirs are there.
Yes, ma'am. But only thing, the issue involved may be left open.
What issue? No, there is no issue to be left open. The issue is all factual issue.
Because in 2014, again,
it has to be, it's not a fresh appointment, it's a continuation. So once you grant him SCP in 96, that means he was subject to correction. Factually, please tell us.
Well, 96 was not, his MSCP was granted on 1/9/2008.
No, SCP was granted in 96. Because he completed his 12 years of service on 12 November 96. Then 2008, the MSCP scheme came. MSCP was granted.
SCP was not granted to him.
Yes, SCP. Sorry, he completed 2 years, however, since he was promoted to the post of Hindi on Athol, he was not granted SCP. Very well. This he did not challenge.
No, my lord.
This he did not challenge.
No.
Then MSCP scheme came, MSCP was granted. as he completed 10 years of service as Hindi officer from 98. That is which you treat to be his fresh appointment. Correct?
My lord.
Came into effect on 1st.
But my lord, I have to admit that in November 2014, he was given another MSCP, my lord. Though, if he's counted that way, he was not entitled to that, my lord.
Sorry, in 2014 he was granted?
My lord, Lordship, kindly see third page, my lord.
Yes, yes.
On the right-hand column, my lord, granted with effect from 16/11/2014.
Third financial upgradation. Now, this was only possible if you go by your 2008, then he's not eligible then.
My lord. So this was wrongly granted to him.
No, 16 November 2014, when you give them MSCP, he has not completed his 10 years of service.
No.
But
So here the department counted from 84, my lord.
That's what I'm saying.
My lord. Even the department is a mixed up things, my lord. That's, I admit, my lord.
You would be entitled to second financial upgradation provided it is counted from 9th August to 1998, correct?
Yes. If 98 appointment is taken as fresh appointment, my lord, then first MSCP 2008, then second will come in 2018. In the meantime, in 27 is superannuated.
No, but if it is not counted from 1999 as his fresh appointment, then he will be entitled to second MSCP upgradation.
Yes. That is the only difference, my lord. The third, the department itself is granted to him, my lord.
What is the letter of 18 February 2017?
February.
2017?
18th February, my lord.
18th February, yes, yes. Annexure 13. What is Annexure 13? 13 is, yes, 46.
Page 46.
19th March 2012. So you find out from that is No, we can also say that it's appointment also considered people. Amount also given. Judgment systems. Investigation they won't get sent to. So in the DPC that was held in 1998, the DPC is a departmental promotion committee.
Yes.
It's not a fresh recruitment. It's not by an advertisement. So what you do that you abolish that post,
Yes.
but DPC can be only for not fresh recruitment, it can be for promotion only. See, two things were there. Either you abolish that post means termination. Service should terminate it, you call for the advertisement, make a fresh recruitment.
There was no advertisement for this post, my lord.
So
Only
when
the-
he appears with the DPC, that means a promotion.
Only he was considered, my lord. Only he was considered, my lord. There was no advertisement, only he was considered. DPC was constituted only for him, my lord. Page 18 indicates that, my lord.
Just But promotion issue has already been decided, as my brother has shown me. The appointment of the applicant as a Hindi officer as promotion was decided in the earlier way, already 9 June 2010. So it's a closed chapter. See paragraph 15.
Sorry, I missed this. So, my lord, in any case now, because
it's a promotion.
Yes. So we proceed, even if we proceed on that assumption, my lord, it is a promotion, my lord. Now he rendered service of 30 years, my lord. The only total entitlement is 3 upgradation, my lord. And promotion is to be set off against 1 MSCP. Now, your lordship will see in 98 he was promoted, my lord. Since we take that as promotion, my lord.
What the tribunal has said.
And 2014 again he was.
He's entitled to 3 financial years. He's entitled to 3 financial upgradations.
My lord. So now, my lordship, in 98 he was given 1 promotion, my lord. And 2014 again he was redesignated to a higher post, my lord. So these 2 have to be deducted from that, my lord. At the most he will be entitled to 1 financial upgradation, my lord. 98 promotion and 2014 redesignation to higher post, my lord.
So that issue is not decided by the tribunal. Tribunal simply said, accordingly, set aside and quash the impugned letter of this and direct the respondents to grant the applicant first and second financial obligation in the great pay of within such and also third financial obligation modification of such along with all constitutional benefits. So nothing is more than said by the tribunal. If you have already paid him some amount, then you deduct it, no problem. That's a different issue. It's what is entitled that the tribunal said. If you have paid already some benefits to him, that benefit has to be deducted when you recalculate it. Isn't it? You see that paragraph 22?
Well, dates have been mentioned, my lord.
Para 22, please see para 22.
Accordingly, we set aside and quash the impugned order and direct the respondent to grant applicant first and second financial upgradation in the grade pay of so and so with effect from 1/9/2008.
Yes.
And also third financial upgradation from 14/11/2014. So, my tribunal is directed to give 3 ACPs, MACP, my lord.
So if third MSCP will be there, provided his 84 is calculated.
Yes, my lord.
So that is why he is entitled to 3. Then even he is
Now,
entitled
because in the meantime, he has been granted promotion and 1 redesignation, my lord. So he'll not be entitled to 3 more upgradation after that, my lord.
No, it was restricted to 3 upgradations only. The order is restricted to 3 upgradations only. The order is
Because upgradation is in lieu of promotion, my lord. Because somebody is not getting
because
promotion.
it is a stagnation. Maybe
Stagnation, my lord. In his case, there was no stagnation. 98 he received a promotion, my lord. 2014 again he gets a sort of promotion, my lord. There's a redesignation to a higher pay scale.
But if you have given the MSCP in 2014, that means you don't consider it to be a promotion to that effect. If you give a third MSCP, third financial benefits, which you have given in 2014, then according to you, he is not entitled to MSCP at all. Your case is then he is not entitled to MSCP at all.
He was entitled to 1 MSCP, my lord, because 2 promotions he got, 98 and 14, my lord.
See, first SCP he is entitled to, which you have not given to him in 96.
My lord.
That SCP he has not given to you,
Yes,
although he is entitled.
We are saying because he was promoted, my lord, he received a promotion, so that will be set off against first ACP, my lord.
Now, in 98, according to you, you give him an appointment. That is your case is appointment, not promotion.
No, even if you go by promotion, my lord.
So if he gets a promotion, then no SCP benefit is there. And then from 98, 98, and then your MSCP came in 2008.
Well,
so these 10 years, he qualified under the MSCP.
Yes, my lord.
So according to you, he is entitled to first upgradation in 1998.
2008, that was granted.
2008.
That was granted.
And the second upgradation would be in 2018.
18, my lord.
In the meantime, 2017.
In the meantime,
so he is not entitled to the second upgradation.
My lord.
This is factually not correct, my lord. This is factually not correct. He is arguing against his own written statement filed before the tribunal.
Wow. In the earlier OA,
attain finality.
Yes, it was said tribunal held that appointment of the applicant as Hindi officer
is a
as promotion.
My lord.
So if it is a promotion, then he is not entitled to SCP. He is not entitled to SCP.
He is entitled to, provided because this proportional scale 6,500 and 10,500 and my feeder cadre post 5,000, 8,000, all 3 got merged in following recommendation of the 6 CPC. And Lordship will find in the impugned judgment, your Lordship, page impugned judgment, it was quoted, para 5. Para 5, Wha- 114, my lord. 114 of the impugned judgment, internal page 22.
Yes.
My lord, in the last part,
Promotion
one
earned
quotation
also
is there.
granted.
Promotion earned, upgradation granted in the last para. It is DOPT OM, my lord, DOPT, Government of India OM. Promotion earned, upgradation granted under the SCP scheme in the past to those grades which now carry the same grade pay due to merger of the pay scales, upgradation of posts recommended by 6 CPC, 6 pay commission shall be ignored for the purpose of granting upgradations under modified SCPs. Now I'll show your lordship. That was quoted in the next page, how it is to be. And then, my lord, page all the scales. Page 116, your lordship. The 3 scale is quoted by the learned tribunal. I was there in 5,000, 9,000, my lord. And I was promoted as in the grade of 6,500, 10,500. From 5,000, 9,000. 6,500, 10,000. And all the pay scales were given the same grade pay. 4,200, 4,200, 4,200. Therefore, the Government of India says it should be ignored in the DOPTOM. It should not be treated, he should get a further financial upgradation. When both the higher scale, promotional scale, and the feeder post cadre scale got merged together. That was quoted in para 5. And even this honorable court also, in a separate judgment, also held in Nehu case, also held same thing, my lord. I mean, I have brought that judgment.
Yes.
And my lord, another thing, they have not placed 2 vital documents because the Hindi officer scale was replaced by 6 CPC by an office memorandum. Office memorandum, it was given 5,400 replacement scale following the recommendation of the 6 CPC. That was there in the original application. They have annexed the original application, but those 2 vital documents were not there. Lordship, that reference of 2411,
No, but these
that
documents.
is the crux of the matter. Para 19, your lordship. Para 19 of the impugned judgment.
Oh, no.
Page 112. Page 112, 20, in the last 2 lines, DOPTOM dated 24/11/2008 and 27/11/2008. By this 24/11/2008, the pay scale of the Hindi officer was replaced by a higher scale of higher grade pay of rupees, my lord, higher grade pay of rupees 5,400.
Now these 2
5,400.
Now these 2, where are these 2 DOPTs?
That was there in the OA, but they have annexed the OA. That was not.
You have not annexed this document.
This document they have not annexed.
Which document?
24/11,
Paragraph
2008 and 27/11, 2008.
It was
Page
there-
112.
It was there in the original.
Or in the original application.
Have you annexed all the papers?
And that is the crux of the matter.
No, all the papers or all the papers used before the SCAT. Have you annexed that?
That was annexure 5 in the OA. 5 and 6.
Well, I'm not very sure about that, Milord.
It was not annexed.
No, but
It is the crux of the
no,
matter.
in this petition you have not annexed the opposition reply. No.
Our reply is at page 82, Milord.
That reply is there.
Some annexures with the reply have been left out, Milord.
Then you do one thing. Whatever annexures have been left out,
Well,
you file a compilation of those within a week. We take it out for a fortnight. Take it down. We have heard the land council. We have learned DSGI.
Item number 1.
Is your other side there?
Yes, sir. It's a very short matter, my lord.
No, but one thing, madam,
Yes, ma'am.
what is the assurance of the value of an indemnity bond? No, nothing. Tomorrow you become an insolvent. What will happen?
The court has, along with the indemnity bond, court has also
Bank
directed to
guarantee.
give
You give
details
bank
of the
guarantee.
property.
You give the bank guarantee.
My lord, I have this Honorable Supreme Court's order is also there where even on it is the
That
recent.
is on a different issue. That you will find in the land loser's case.
No, in
The
this
judgments-
Amazon case, my lord, 2020.
Amazon versus future technologies.
No, this is in lifestyle equities.
Lifestyle equities, and you are on a different footing.
No,
Lifestyle
not on the
equities-
subject matter. Yes, my lord.
If you want to withdraw the balance 50%, you furnish bank guarantee.
Yes, for
Because I don't find the prima facie, I don't find the award foolproof.
no, my lord.
I'm not hearing on that. I'm not. That I don't want
So
to
far
make
as
any
the
comment
challenge
on
to
this.
the award is concerned,
Comment on
my lord.
this. But I think this matter was sent to mediation, ought to have been settled in mediation.
Yes, sir.
So, if you
My lord, here the court has allowed us to withdraw 50% on bank guarantee.
have yes. So
Yes.
another 50% you can withdraw on bank guarantee.
No, the balance 50% on indemnity bond with providing details of the properties also, my lord. And so far as my lord, if your lordship will kindly allow me, that even in another case also, Honorable Supreme Court has said even on personal security, big amount was allowed to be withdrawn. And in what is the security which is mentioned?
I have gone through the award, madam.
Yes, my lord.
If you want to allow withdraw another 50%, furnish bank guarantee. This is my view.
My lord,
And at what stage is the setting aside application?
It's ready for hearing, my lord.
So then I will direct the trial court to hear out the matter as expeditiously as possible.
this matter.
But this matter,
My lord, firstly, on this matter, so far as withdrawal is concerned, that is a secondary matter. But the most important is whether this civil revision is maintainable. Because this will create a precedent for future cases also. Civil revision against an order under the Section 8 of the Commercial Codes Act, civil revision is not maintainable, my lord. So whether this Honorable Court will exercise 227 in this kind of situation where there is no challenge to the...
this is arising out of,
In the execution case, my lord.
yes, Arbitration Act.
Arbitration Act in the
It's an Arbitration Act.
but it is filed under Commercial Code Act. In the Commercial Code.
Commercial Code will have the jurisdiction to decide.
Yes. And the execution is filed before the Commercial Court.
No, give the commercial.
Arbitration Act is providing for appeal. Appellate provision is there.
This is not an appealable order.
Is it an appellable order?
This is not, my lord.
Huh?
Not under 37.
Yes, this is not an.
Appealable under 37, my lord.
So this is not an order appellable under
37.
37.
And Section 8 of the Commercial Codes Act bars jurisdiction, civil revision. It says bar against revision application or petition against an interlocutory order. This is an interlocutory order passed by the Commercial Court as an executive court, by the Commercial Court.
This is at the level of the district judge, correct?
Yes, my lord.
Yes.
No, of course, no act can curtail the power under Article 227.
Yes, my lord. But again,
So he, at the same time, he cannot be held remediless.
but they couldn't
so-
file appeal under Section 13 of the Commercial Codes Act.
No, it cannot be, because it has to be because of proviso to 1A, because it is arising out of the Arbitration Conciliation Act. So it has to be an order. This order was passed in the jurisdiction of the Arbitration Conciliation Act in execution of the award.
Yes, my lord.
So it's a 36 proceeding. It's an order passed under Section 36 of the Act,
Yes.
where the provision of, we may take recourse to the provision of CPC.
Yes.
We take the recourse of CPC for the purpose of execution, correct? Enforcement is by the enforceable in accordance with the Code of Civil Procedure.
Yes.
Now, so according to you,
My lord, it is a fact that Section 8 of the Commercial Codes Act said against interlocutory order of a commercial court, no revision will lie. Of course, definitely that cannot curtail the or bar the jurisdiction of
And
a
also
Honorable
the-
High Court under 226 or 227.
and if it is covered, and also all appeals under Section 37. So Section 37 is all appealable. Refusing to refer, granting or refusing, setting as a reference set as an arbiter, an appeal shall lie to a court from an order of the arbitral tribunal accepting such and such. No second appeal should lie. So these are the restricted appealable orders. Now, when the execution proceeding is taken place, it is under Order 21.
Yes.
Yes.
It's under Order 21.
The Order 21 will be followed. The principles
So
of Order 21 will be
So
followed.
Order 21 will be followed.
Rule 5.
Order 21 will be followed
Yes.
for the purpose of enforcement.
Court will follow that.
Court will follow the arbitral court will
Principles
follow-
of Order 21, Rule 5, my lord. And CPC, that procedure Rule 5. Now, my humble submission was in the first stage, my lord. Order 21, Rule 5, nowhere speaks that that is dealing with stay during a stay of execution or stay in the appeal. When it is a money decree, whether security has to be given. That is what the Honorable Supreme Court in this Amazon case has held. It does not spell out that a security has to be in the form of a monetary security. It can be any bond, anything. That is what the operating portion of the judgment, Your Worship. Take out the judgment. Yeah.
See, any order, all orders passed under Order 21,
Yes.
you are referring to Order 41, Rule 5.
Order 21, Rule 5.
No, Order 21, Rule 5 is
Which
something
says
else.
stay of the execution.
That is Order 41, Rule 5. That is Order 41, Rule 5.
Wait.
Rather, Order
Yes.
43, Order
Order-
43, Rule 5. Order 43, Rule 5.
41, Rule 5, my
No,
lord.
Order 43, Rule 5. That is your Order 43, Rule 5. And all orders under Order 21 are not appealable. So wherever it is not appealable, it has to be revisable. If you see appeal from orders, that is Order 43, Rule 1, it categorizes which order are appealable orders.
Yes, my lord. Then again, in view of the
And-
amendment
or-
of CPC, my lord.
And Order 43, Rule 5
Yes.
is on the stay. Money decree, if you don't deposit, then they did not operate as a stay. But we are in a situation where proceeding under Order 21 was filed for the purpose of enforcement of the award under Section 36.
No, we did not quote. We had under 36 of the Arbitration Conciliation Act for enforcement of the award we have filed execution before the Commercial Code. And as per the Act, the Commercial Code will be guided. It is in the Arbitration Act says so far as for that,
the procedure of CPC will be
Commercial,
applicable.
Commercial Act has made a specific reference to Section 37. What would be that is a proviso. You see the Commercial Act Section 8, the one you read out. You read the proviso. It says provided that there's a Commercial Courts Act. Where's Commercial Courts Act?
Any such challenge subject to the provision of Section 13
Yes.
shall be raised only in an appeal against the decree of the Commercial Court.
Now, provided that an appeal shall lie from such orders passed by the Commercial Division or Commercial Court that is specifically enumerated under Order 43, because it's an order, as amended by this Act and Section 37 of the Arbitration Conciliation Act.
Your Lordship is in which section?
Is Section 13 proviso 1A, under 1A.
This is about the judgment and decree. We are here at the interlocutory order, my lord.
Yes.
This is talking of judgment and decree. This is an interlocutory order, and in view of my lord,
Section 37 is an interlocutory order. Section 37, it said appealable orders.
appealable order.
So it's
not
an
an
interlocutory order. Appealable orders.
But it is against the judgment and decree, my lord. Appeal will be filed against the judgment and decree, not against the interlocutory order.
No. Section 37 are appealable orders, correct?
Yes, my
What
lord.
orders are appealable? Section
Appeal-
34. Section 34 will be appealable.
But
Any order refusing whatever is enumerated is appealable. Now here you are on the enforcement of an award. So enforcement of an award is by reason of the Arbitration Act. The procedure to be followed is CPC.
CPC, my lord.
In the CPC, an order was passed. In the CPC, an order was passed under Section 21 for execution. So, if he passed an order in execution, that order, neither under Code of Civil Procedure nor under the Commercial Act, if you read it, is appealable. This order passed in execution is not an appealable order. Under, if you read this order, section, if you read Order 43, is it an appealable order? Find out it's not an appealable order. Which orders are appealable? Now, to find out on this, you fall back on Kimji's judgment. What would be an appealable order? Explain in Order 43. Kimji's judgment said what would be the appealable order under Order 43. Read with the latest patent appeal under Clause 15. Whatever, for High Court, Calcutta High Court is Clause 15. The High Court may be different latest patent provisions. But Clause 15 of the latest patent, as far as High Court is concerned, whatever the latest patent provisions are there, so it excludes latest patent. So, he cannot avail of the latest patent. But this order under 227 remains. He can. Because even the judgment, because even the judgment of the Supreme Court,
yes, my lord. Yes.
where Section 16, 5 and 21 came up for consideration, their lordship said in an unequivocal term that a litigant cannot be held remediless. And where it is found that he becomes remediless, 227 can always be excepted. It's an exception. Constitutional power cannot be curtailed.
Constitutional power cannot be
And
curtailed.
if it is an appellable order, the law says that 227 may not lie. It's a discretion. If it is an appellable order, suppose an order is passed, say appointment of receiver under Order 40, it will be an appellable order. But if you find 227 or 115, the court may say, notwithstanding the sweeping power of 227, I may not exercise my jurisdiction. But here under 227, the court has an exception. This power cannot be curtailed by any statute. That's why I was a little surprised when you say the revision is not permitted. But legislature has.
Yes, what
that will
I
be
was
basic
submitting,
against
my
the
lord.
Constitution.
What I was submitting,
But in
my
any
lord.
event, we'll not
Because
direct.
227 power cannot be curtailed.
Sorry, take down. This revision under Article 2.
Well, this is an application against the order passed by the learned first appellate court, my lord.
First appellate court, yes.
Yes. However, the genesis of the case is that
Yes.
you will take.
What is the date of the impugned order? What is the date of the impugned order?
Your Lordship, I pray for some accommodation, Your Lordship.
For
Because
accommodation?
Yes, Lordship. Because this matter is being led by Mr. P.R. Pasque. And he has-
Your friend wants an accommodation. Last time on your request, the matter was adjourned. Very well. When should I keep it?
2 weeks, Your Lordship.
2 weeks. A prayer for adjournment is made on behalf of Mr. R. Pasin